talk more about this case with legal expert Ulrich le Roux. Ulrich, always good to have you in Newzroom Afrika. So the former president's legal team, in its response to the news from the Supreme Court of Appeal, has said that it will continue, or he at least will continue to fight on to have the lead prosecutor, Advocate Billy Downer, removed from his corruption case. Could a constitutional court give them a better outcome?
Hi, good day, Tembekile. Thank you for having me on the show. Yes, certainly I think that we would be very ignorant if we thought that he wouldn't. If you look at Jacob Zuma's track record thus far, he has done everything possible and he has launched every single interlocutory application possible in order to prevent this trial from proceeding and in order to frustrate the process. So yes, he would always have an opportunity to approach the Constitutional Court. He would have to seek direct access to the court, and I think that we can expect him to do so. And
it's one thing for the former president's legal team to explore various legal avenues, right? When the issue of the recusal of Advocate Downer was discussed in the High Court, the court found that it basically did not warrant the recusal of Advocate Downer. The SCA, on reconsideration, has also said it's not really a matter worth dealing with to the extent where he's removed. Now, at the Constitutional Court, how would the former president have to approach that to even make that case when two other courts have already said, actually, no?
Yes, you're 100% correct. He even took it one step further where he directed an application to the Judge President Maya in order for her to reconsider the decision made by the judges sitting under her in the Supreme Court of Appeal. Our rules of appeal in South Africa states clearly that you will only be successful in appealing a matter or in obtaining leave to appeal a matter if you can indicate, based on the facts, that there's a reasonable foreseeability that a higher court will reach a different conclusion. And that is what he will have to prove when he approaches the Constitutional Court. He would have to direct his application to the court, first seek permission for direct access to the court. So in other words, it is not a matter that has automatically been referred to the Constitutional Court. And if he does get granted permission for direct access, then he would have to make it a very strong case out to show that the Constitutional Court judges will, upon adjudicating his application and upon proper consideration of the facts contained in his application, reach a different decision. That decision being that, yes, there is in fact merits in insisting that Advocate Billy Downer must be recused from his matter because of the medical records situation, as well as the fact that he says that he is acting in a biased manner towards Zuma. In my opinion, I don't think that the Constitutional Court will even grant him direct access, and I do not foresee the Constitutional Court ever deviating from the decision that, as you correctly pointed out, has already been made by the High Court in Pietermaritzburg, then by the Supreme Court of Appeal in Bloemfontein, and then by the Supreme Court of Appeal Judge President Judge Maya. So I don't think that there's any prospects of success should he launch such an application to the Constitutional Court.
Well, given that he's yet to launch such an application, what does it mean for the resumption of the trial and the trial actually going ahead for the 15th of August? Am I right to say that at this point appears unlikely?
Yes, well, at this stage, the trial is set to resume or to start on the 15th of August. That was an order made by Judge Kuhn on the previous occasion. The discretion will still lie with him. So if, for instance, they do launch an application to the Constitutional Court, they will then have to bring an application on the 15th of August saying to Judge Kuhn, well, we've launched this application. We believe that it could be successful. We are still awaiting the outcome of the application, and accordingly, my trial must be postponed until we have clarity pertaining to the Constitutional Court decision. On the other hand, if they do launch that application timeously and the Constitutional Court does have proper regard to that application and reaches a decision prior to the 15th of August, then there would be no reason for further postponement. But at the end of the day, Judge Kuhn will be the presiding officer who will decide whether the matter should be postponed or not. But on that note, should they still await the outcome of the Constitutional Court and Judge Kuhn insist that his trial must continue, then I think we could expect an application to have Judge Kuhn recused. So, you know, it's just a matter of Jacob Zuma once again kicking the can down the road and delaying the process, which is ironic in itself, given that he was the man who 4 years ago made it abundantly clear that he wanted his day in court and he wanted to prove his innocence, and yet now he's doing everything within his power to prevent that from happening.
Interesting you say that, because at one of the last discussions that when the High Court in Pietermaritzburg was dealing with the issue of whether, as the state was saying, that the former president was basically exploiting avenues in law to avoid a trial, Judge Piet Koen himself said it could not be argued that it was, shall we say, a frivolous litigation, as it were, and that the former president was allowed indeed to continue to explore these avenues within his rights in law. Do you expect that that will come back again when we go back to the High Court now that there's been a dismissal of this application by the SCA president, be it we've got the Zuma team saying they're likely to lodge another battle?
Yes. Yes, well, all the applications lodged have been in accordance with our law. In my opinion, they have all been frivolous in that there's never been any merits in those applications. So, you know, the chance of success has been very little from the outset. But that does not prevent a person from acting in accordance with our law and launching such an application. There's, of course, a cost aspect to this as well. Every time that he loses these applications that he launches, he is ordered to pay the costs of the opposing side. And, you know, that is the only way in which a court can really deter a person from launching a frivolous application. But you correctly say that, and Judge Koen is also 100% correct to say that he has this opportunity to act in accordance with the law to bring an application, and it is not for any presiding officer to refuse him that right. So in terms of our Constitution, he is in a position to approach the Constitutional Court, and one can definitely expect him to do so.
Ulrich le Roux, good to have you. Your time as always. Thank you very much.